The purpose of today's meeting is to begin a series of engagements examining the direct provision system and the international protection application process. We are joined by Dr. Brian McMahon, former Judge of the High Court, who also chaired the working group on the protection process and direct provision. You're very welcome. From the Immigrant Council of Ireland, we are joined by Brian Killoran, Chief Executive Officer, and Mary Henderson, Solicitor, and you're both very welcome here this morning. And from the UNHCR Ireland, we are joined by Enda O'Neill, Head of Office in Ireland, Maria Hennessy, Protection Officer, and Caroline Stevens, Protection Assistant, and you're all very welcome too. I'd like to also welcome our visitors in the gallery from, I understand, the Jesuit Refugee Services Ireland and Tá Fáilte Romhaibh. So you're all very welcome, and just to indicate to you, as you might expect in a week such as this, we've had some apologies from colleagues who were not at full strength this morning. Something to do with something happening on Friday might be an explanation for that, but so be it. That's part of life. I intend to invite you to make your opening statements in the order in which I've introduced you, if that's okay. But before we commence, I have to draw the attention of the witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him or her or it identifiable. Members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. And before we proceed, I'd just like to ask everyone to make sure that your mobile phones are on silent, please. So I'd now like to invite Dr. McMahon to make his opening statement.
And members of the committee. The single most important issue identified by the working group in 2015 that had to be resolved was the length of time that many in the protection system had to wait before their application was fully determined. It is worth noting that at the time of the working group negotiation, more than 50% of direct provision residents were 5 or more years in the system. The legal process was complex and protracted, as a result of which many remained in the system and in direct provision centres for many years before their application for protection was determined. Confined in centres designed initially to accommodate people for no more than 6 months, and where all meaningful employment was prohibited, the residents found that the living conditions became increasingly oppressive as the waiting periods drifted from weeks to months to years. Recent trends in the number of asylum applications and the direct provision population indicated new fault lines are emerging in the system. There are now approximately 6,100 people in direct provision. 4 years after our report, however, it is worthwhile to review the progress made in implementing the working group recommendations. Because of the limited time available to me, I will concentrate on big-ticket items, if I may. Firstly, let me talk about the right to work. Combined with the long time in direct provision centres, applicants who were denied the right to work suffered incredibly as a result. They became de-skilled, depressed, and felt themselves useless, to say the least of it. One quote I remember from one of the residents was, "As we wait for time, time kills us." So it was a depressing kind of a scene. The recommendation of the working group was that those waiting for first instance decision for more than 9 months should have access to the labour market. The Supreme Court in May 2017 held that the blanket ban in place against working was unconstitutional, and unusually, the Supreme Court asked the government to put forward its proposals to rectify the situation. After some toing and froing and some hesitation, the government went beyond what the court required and opted into the EU Recast Reception Conditions Directive, something that was advocated by some reformers for a long time. It could be said, therefore, that the Supreme Court's intervention at the end of the day prompted a more generous response from the government than that suggested by the measured proposal from the working group made 4 years earlier, much to the advantage of the protection applicants. So they have the right to work after 9 months. The question remains, however, whether the right to work is fully effective, as it appears that some difficulties have arisen when residents in direct provision sought to get a driving licence or to open a bank account. Moreover, the opportunities to work may be restricted for residents located in remote centres. Such obstacles should be removed if it is shown that they restrict the residents' right to the labour market. I visited a couple of centres in the last week. In one centre where they had 57 residents, 38 of them were now working, and 3 of that group were in further education. Another centre, which was for women only, had 86 residents, and something like 70% roughly were working. And a third centre where it was men only, again had about a 70% work rate. Now, I hasten to add that these were in a centre where work was available and it was a tourist centre. But the morale in the centres where people were working was wonderful and is very much appreciated. The second issue was the allowances. The working group recommended that the allowances of €19 for adults and €9 for children should be doubled. That was not done immediately, but it has been done since, and in the last month these allowances are now doubled. And that again, together with the right to work, has made a significant difference to the morale and comfort of the residents in these places. The third thing that I might mention is that the role of the ombudsman, men, both children and adults, has been extended to cover residents in direct provision centres. That was sought for by the residents, and it has a very liberating effect, and it has a comforting effect that they can now make complaints without the fear of retribution. The fourth issue I want to mention is cooking and independent living. One of the big complaints that we got from residents was they couldn't make independent decisions about eating. They had to go to canteens at given times and eat the food that was presented to them. It was a big issue for families in particular who were denied the privilege of sitting down as a family, purchasing making choices in relation to food and their culinary preferences, and sitting together as a family at given times. Progress has been made in some of the... We recommended that all the centres should have independent living, in the sense that there should be a shop where they could purchase their food and facilities to cook it themselves. I think in about 38% of centres now, this has been done. And in another 1,400 residents have the right to cook, but they haven't got the shop to buy their own foods. They have to shop elsewhere. So some progress has been made, as I say, in that respect. But it is significant to note that none of the state-owned centres have as yet provided access to a food hall and cooking facilities under the agency's independent living model. The state owns 7 centres, and none of them have provided facilities for cooking for independent. I am informed by the department that there is ongoing discussion between the Office of Public Works in this regard. There may be technical, logistical problems, but it does seem stark that 38, about 50% have some form of cooking, but the state haven't provided anything. The accommodation standards was another area where we concentrated on. It was felt that the accommodation in some of the centres was lacking, and we made recommendations that there should be some kind of a uniform minimum standards. I'm happy to say that in the last couple of years, national standards have been drafted and are now with the government for final approval, which incorporate the minimum requirements set out in the recast Reception Condition Directive. So this should help to promote equality, prevent discrimination and protect human rights as defined by the public sector equality and human rights duty. Moreover, future tendering competitions will insist that all providers must demonstrate their ability to conform to these statutory obligations. Sixthly, a phenomenon that has asserted itself in this country since the report was published was the shortage of accommodation generally in the state. And the shortage of accommodation across the state, noted and considered by the working group, has become more acute since 2015. I needn't tell you that. You're dealing with it every day of the week. In 2018, there has been a sustained increase in new applications, averaging more than 300 a month. And this has put greater pressure on RIA's existing stock, in that more protection applicants continue to live in direct provision centres while waiting for determinations. Alternative accommodation is not readily available for those who wish and might wish to avail of it were it available. They can't move out with papers. So those who have received positive decisions are obliged to continue to live in direct provision centres for the same reason. At present, it is estimated that there are 800 or thereabouts, 700 or 800 such persons trying to transition out of direct provision but cannot do so. It costs, RIA is also obliged, because of the shortage, to engage in emergency accommodation. That means the accommodation outside of the centres. And this is a costly business. It costs, I think, €99 a night to accommodate people who can't be accommodated in direct provision centres. It may be understandable that they should do this so that the protection applicants have a roof over their heads. But it is important that the lessons of the wider housing sector are learned, and that this short-term fix does not become a long-term solution. Also, in light of the very high cost of emergency accommodation, one wonders, in these circumstances, whether it would be more economical for RIA to consider expanding their own stock by building on state-owned sites. I leave to last the most important issue that was identified by the working group as a problem in the system, and that is the processing, the length of time that applicants remain in the system. And this is due to the processing. The working group, to cut it short, the working group felt that anyone in the system for more than 5 years should be got rid of, in the sense of they should be dealt with expeditiously and they should be fast-tracked out of the system. It was felt that that was the humane thing to do. The 5 years was fairly arbitrary. 5 years is a long time, but we were talking about people who were there 6, 7, 8, 9 years at that time. So we felt that the 5 years should be set as the minimum. Now, we felt also that if that was not done quickly, that group of people would continue on to the new system which was introduced in 2015 in the single application process. The single application process was agreed by the government before we were even sitting, that they were going to introduce a single process. This was to simplify the legal process and to reduce the 3 hearings to 1 hearing. And that would single process. But we warned, and the working group was very strongly of the view, that unless you cleaned out the backlog, that backlog would continue to contaminate. I don't mean that in a pejorative sense, but to upset the expeditious dealing with the rain that would come in. And that the government did not accept our proposal on that. They did, however, on an ad hoc basis, try to address the 5 year plus people, and they got through 2,000 of them fairly quickly in the next 2 years. But there still was left a bulge in the system, which continues to today to go through the system and clogs up the administration. The current administration, in dealing with these matters, about 3,600 every year come in. We're told that they're able to process 3,900. So if you were only dealing with the current people coming in, the present system would adequately deal with them. But it's complicated by the legacy that I've spoken of coming into the system, so that there is still a delay. Nowadays, there is a backlog of about 19 months before an applicant can have his case heard. 19 months. Now that is too long. The department is working on it to try to get it down to 15 months and 12 months, and they're hoping that within a year they will. But those are aspirations. At present, there's a 18 to 19 month delay between your application and your processing. So that is too long. The ad hoc scheme for long stayers ceased with the commencement of the International Protection Act in January 2017. However, 4,000 existing cases still in the system were transferred into the new single procedure. The failure to deal with this group, as the working group had recommended, hindered the success of this new single application system. This is far too long. Finally, let me conclude. There have been a lot of improvements in the system since the working group has made their report. It's not perfect, but this is a changing space. And this has to be monitored every year to see that the improvements are made. It was submitted that in 2017, the working group report was the first review of the analysis of the direct provision system since it was introduced. And membership of the group included representatives from every department involved, and it included NGOs working in the area, a number of academics and other experienced individuals. For the most part, the recommendations made by the working group are pragmatic and achievable, and this is not surprising given the membership of the group. In particular, the public servants from the various departments ensured that the political realities were well articulated when possible solutions were being debated. The report provides a valuable infrastructural analysis of the direct provision system and identifies many problems and issues of concern, as well as suggesting reforms in many areas. Some of the recommendations were adopted and implemented fairly quickly, while others were deferred. Even where there has been delay, however, the report has kept the direct provision question continuously on the political agenda. In any event, it is generally recognised that the programme of action set out in the report is still valid and is still one that the government is trying to implement. Since the publication of the working, there has been significant improvements, including the resolution of an estimated 2,000 long stayers who were here in the system for 5 years, the establishment of a new international protection procedure, the introduction of communal catering in family centres for many, the extension of the role of the Ombudsman offices, the introduction of a right to work for eligible protection applicants, increased direct provision allowances, and the development of a national standards for accommodation provided. While there has been considerable progress, there still remains significant work to be fully implement the working group's recommendation. And there are concerns that some improvements are certainly being unwound by the accommodation crisis. Without doubt, the housing crisis poses the greatest practical challenge to identifying an alternative to the direct provision system where residents might be allowed to live with greater dignity. Finally, it should be acknowledged, however, that 4 years have passed since the working group report was published, and there have been significant changes at home and abroad in this area in that time. In particular, one might mention in this regard the following: Brexit, Angela Merkel's unilateral acceptance of 800,000 migrants into Germany and the backlash that followed, the housing crisis in this country, the election of Mr. Trump in the USA, and the rise of right-wing politics in Austria, Hungary, and other European countries in the East. The rise of right-wing politics, in particular, in Austria, Hungary, and other European. The last time I looked, it was estimated that there were 68 million people forcibly displaced in the world, and there is no indication that a limit has been reached yet in this regard. The landscape continues to change, and the Irish response to asylum seekers who arrive on our shores in search of refuge and protection must also be continuously sensitive to all these geopolitical trends and developments.
Thank you, Dr. McMahon. We're now going to go to Brian Killen, Chief Executive of the Immigrant Council. Thank you, Brian.
Thank you, Ciara, and thank you, members of the committee. The Immigrant Council of Ireland is an independent law centre and NGO that works to protect and support and advocate for the rights of migrants and their families in Ireland. We provide legal information, advice and representation through information and legal services. The Immigrant Council legal team also specialises in the holistic legal aid to victims of human trafficking, in the majority case, in our case, women recovering from sexual exploitation, and we're a leading anti-trafficking advocacy organisation in terms of its expertise and policy and advocating for legislative change in that area. As such, the Immigrant Council's direct experience of the direct provision system derives primarily from our experience of legal representation and supporting trafficked women who are living in that system, and hence that will be the focus of the comments which I make to the committee today. The overall majority of victims of human trafficking represented by the Immigrant Council are housed in direct provision centres, and while this can be seen as a niche area within the overall direct provision landscape, there is much overlap concerning the issues involved and indeed the solutions suggested. To briefly outline the problem, the provision of safe and appropriate housing is an internationally accepted priority need for victims of human trafficking. It's central to their recovery as independent individuals and to fulfilling their potential role as witnesses within criminal investigations. Taking into account the gendered character of trafficking, relevant EU-level directives require that the assistance of victims of trafficking should be gender sensitive and include measures which provide appropriate accommodation and aftercare support for victims of trafficking. Presently, the Reception and Integration Agency is tasked with the provision of accommodation and material assistance to all victims of human trafficking, which is in addition to RIA's main function to house people seeking asylum in general. In this context, our priority concern here lies with women, in some cases underage girls in age determination processes, who are trafficked for sexual exploitation and referred through the national referral mechanism around human trafficking for support. For such women, the introduction of gender-specific shelter and accommodation approaches in Ireland is of central importance. Integrated support such as medical, material, legal and other integration assistance are key components of such support and recovery. It's the long-stated position of the Immigrant Council of Ireland that direct provision centres do not represent appropriate housing for victims of human trafficking. At the same time, the national shelters and other services for domestic and sexual violence are not resourced in any way to formally involved in responding to migrant women in situations of human trafficking. So in general, despite the improved practices and general residential matters in the aftermath of the McMahon report in the working group, the situation for victims of trafficking in direct provision has not changed in any significant way. For example, the sharing of rooms, limitations in food preparation, and indeed sexual harassment, and in general an environment where post-traumatic stress and other issues of mental health that arise out of trafficking situations can be addressed, are not catered for and not responded to appropriately within direct provision centres. Meanwhile, the recommended single female gender hostel which was set up has been located in a location removed from any specialised complementary services for trafficked women in order to become a suitable alternative in these circumstances. And it's our understanding indeed that there are currently no victims of trafficking living in that specialised single gender centre. Also, I suppose in general there's evidence of late that RIA accommodation centres are in cases of supporting victims of trafficking, asking that victim of trafficking to leave the direct provision centres after 60 days, which they believe is the upper limit of their responsibility to supporting victims of trafficking, requiring those victims of trafficking in those cases to then present to homeless services. We hear this from a lot of the support services that we interact with, both state and non-state, that are working with victims of trafficking, which is a completely unacceptable situation in trying to support somebody who has been through an extremely traumatic situation. In terms of international criticism, Ireland's track record in the accommodation supports of victims of trafficking has been noted not just at a national level but also through international bodies such as the Council of Europe Committee of Experts, known as GRETA, and the annual US State Department's Trafficking in Persons, or TIP report, which in 2018 downgraded Ireland from Tier 1 to Tier 2, essentially stating that Ireland is not meeting the minimum standards required to appropriately respond to this complex area. Accommodation standards and procedures being one of the cited areas both by GRETA and by the TIP report in 2018. In terms of recommendations, in the long term, we advocate for alternative housing entirely removed from direct provision centres for victims of human trafficking. However, we are aware that this transition may take time, and again, we are aware of the current context in terms of the housing situation in Ireland. For this purpose, we will, in addition to our long-term recommendations, which I'll touch upon momentarily, we've developed urgent interim recommendations to be adapted or adopted by RIA centres to meet the immediate needs of trafficking victims who are living in direct provision. So in terms of interim proposals as a matter of urgency, we urge that there be designated private non-shared rooms for trafficked women who have been sexually abused and recovering from significant trauma such as depression, anxiety, insomnia and post-traumatic stress disorder. Sharing a room with up to 3 other individuals who are in many cases passing through while trafficking victims can stay there for a number of months is completely an inappropriate situation for a trafficking victim to be in. The provision of self-catering arrangements where women can cook their food as an essential precondition to regaining control and independence through budgeting and exercise of choice must be increased. And to build upon what Judge McMahon has said, it is fantastic that there are improvements in that area, but it is not throughout the system, and that needs to be the case. We need to see increased awareness among managers of centres about their salient role in the delivery of this most vital service to victims of serious crime recovering in the premises they run. And indeed, there needs to be training of key personnel within those centres in understanding human trafficking, the obligations of the state in that regard, and the specific need of victims, with a focus on those that recover from extensive long-term trauma. The provision of a roof over one's head and 3 square meals is not adequate care for victims of human trafficking. There needs to be a significantly improved response in that regard. Also, it needs to be, I suppose, framed in a commitment to gender sensitivity in views of the serious exploitation that the majority of victims of human trafficking have suffered, including, sexual abuse, rape, and other extreme, coerced and extremely damaging practices. In terms of long-term solutions, before I wrap up my opening statement, first and foremost, the Immigrant Council of Ireland calls for gender-specific accommodation services for trafficked women recovering from sexual exploitation, and recognition of the support needs existing among that group. As an interim and immediate measure, nomination of women's refuges for women fleeing domestic violence as emergency accommodation for trafficked victims, and provision of additional resources to those refuges is essential. This is the model of housing for trafficked women that is preferred in a number of EU member states, but again, as I say, calls for significant resourcing of those centres to meet that immediate needs for women fleeing the situations that they're in. Second of all, as a kind of a middle ground, the creating of a shelter that specialises in supporting trafficked, sexually exploited women is of essential importance. This shelter-type facility would offer services to women who require long-term recovery services beyond just emergency accommodation, including legal support, trauma support, counselling support, health support, that is currently available to them only in a sporadic manner. But ultimately, for victims of human trafficking with indirect provision, for their long-term recovery, privately rented accommodation with a geographical spread, located in areas where there are possibilities of wraparound legal, medical and counselling services, such as major cities like Dublin, Limerick, Cork, Galway, is essentially the gold standard to which we need to work. This would involve a flexible number of units and a corresponding budget in dispersed locations to try and support the situations or the accommodation needs of victims of trafficking, and this could be done in collaboration with approved housing bodies. So, in conclusion, I suppose what we'd say is we very much welcomed the reflection of the particular needs of trafficking victims in the McMahon Working Group and in the report and the recommendations that came out of it. This is a niche area with indirect provision, and I think it's internationally and nationally recognised that trafficking victims, because of essentially the high proportion that have been sexually abused over the course of their experience, need an ameliorated or improved level of care than they are currently receiving within direct provision centres, and we urge in the strongest terms that be our priority, both as a state and for the government as well. And I welcome any questions on it. So thank you very much for the opportunity to speak to you today.
Thank you, Brian. Our next speaker, I understand, is Enda, and on behalf of the UNHCR, and I'd like to invite Enda to make his address, please.
Thank you, Caoimhghín, members of the committee. Firstly, let me thank the committee for having invited me to address you on these important matters. UNHCR, the UN Refugee Agency, is mandated by the General Assembly to lead and coordinate action worldwide to protect refugees, asylum seekers and stateless people. We've had a continuous presence in Ireland since 1998, and our supervisory role regarding compliance with the 1951 Convention relating to the status of refugees is recognised both in national legislation, in the International Protection Act, and in EU legislation. As the scope of the committee's work on this topic is quite broad, in my opening remarks I will focus primarily on the protection process and progress to date in implementing the recommendations of the 2015 McMahon Report. The McMahon Report made 173 recommendations across three broad themes: the determination process, living conditions in accommodation centres, and supports for persons in the system. The recommendations were intended to be implemented as a package in advance of the introduction of new comprehensive legislation to address the biggest single issue identified in the report, the length of time protection applicants have to wait for a final decision on their claim. Chapter 6 of the report details the financial model developed in consultation with officials of the Department of Public Expenditure and Reform to project the financial costs of implementing the report in full. According to Para 60.45, the model demonstrates conclusively that investing in decision-making not only will yield returns in reducing time spent in the system, but also makes financial sense. Each year that a person remains in the system gives rise to accommodation costs of €10,950 on average per applicant. The cost of decision-making is a fraction of this cost. As members of the committee will be aware, challenges still remain as regards the length of time applicants typically spend in the system. You should have before you some recent statistics compiled by UNHCR, which point to a number of trends. The number of new applications each month has been rising moderately and consistently for some time now, with an average of 319 new applications per month over the last year, or over the last 2 quarters, an average of 360 per month. Annual numbers of new applications are still, however, far below the peak we experienced in 2002 of 11,634 new applications, and are comparatively fewer than many other EU countries. There were 5,693 applications on hand at the International Protection Office at the end of 2018. This represents an increase on 5,183 at the end of 2017. By contrast, when the McMahon Report was being drafted at the end of 2014, there were 2,402 applications on hand. The McMahon Report at paragraph 6.29 points to the reason for this increase. The number of new protection applicants in 2015 has outpaced the capacity of available resources to process these applications. A failure to provide decision-making bodies with the further additional resources to process these cases will result in a new backlog affecting those in the system for shorter durations. As a result of the failure to take steps to substantially reduce the number of cases on hand prior to the commencement of the International Protection Act 2015, transitional provisions of that Act resulted in approximately 4,000 cases being transferred to the IPO from the old tribunal, referred to as legacy applicants, on the 31st of December 2016. Despite a considerable increase in productivity by the IPO since then, the number of substantive decisions taken in 2018 remained lower than the number of new applications received that year, 3,319 compared to 3,673. The current median processing time for new applications received under the International Protection Act 2015 stands at 15 months. Additional resources have recently been assigned to the IPO, however, with a view to meeting their target to reduce average waiting times to 9 months for a first instance decision by the end of 2019. All remaining legacy applications considered live at the end of 2018 have been scheduled for interview by the IPO, with final recommendations intended to be issued on these cases by the end of Q2. A separate unit within the IPO is currently examining non-cooperation cases, such as where an applicant's whereabouts is unknown and there is an ongoing lack of contact with the office. There are an estimated 1,200 applications in this category, which are being worked on to bring them to finality as quickly as possible. Notwithstanding these positive indications, I would reiterate my concern at the length of time it currently takes to determine an application for international protection, and recall the McMahon report recommendation that the decision-making bodies be staffed on a continual basis with sufficient staff to ensure that it can respond appropriately to the number of applications it is receiving at any given time. Just as it was in 2015, the length of time protection applicants have to wait for a final decision on their claim remains the key factor affecting applicants' experience in the direct provision system. Long periods spent in direct provision can impact the future employability of refugees and on their mental health. To conclude, I would also like to make a broader point in relation to the working group. That process, in my view, benefited enormously from a unique collaboration between civil society and government, with members displaying a commendable commitment to attend weekly meetings throughout much of their duration, despite their heavy professional responsibilities. It was always envisaged that a new body, similar in structure, would continue this work after the publication of the report. It is regrettable, therefore, that the recommendation to this effect was not implemented, specifically that an independent advisory board be established and given all the necessary flexibility to consider all matters related and relevant to the operation of the system. An annual review of the system was also recommended with a view to making recommendations to guard against any future backlogs, for example, failure to provide adequate resources to all decision-making bodies. Finally, in relation to the living conditions in accommodation centres and supports for persons in the system, you should already have been given a copy of an article written by my colleague Caroline Stevens here beside me last year on developments in the direct provision system since the McMahon report. You should also have before you a submission on measuring outcomes and supporting refugee integration. Time will not allow me to specifically address the contents of those submissions in my opening address. However, I would welcome any questions you may have in relation to them, or indeed any other matters relevant to your deliberations. Thank you for your attention.
Thank you very much. And just to thank all of the contributors this morning, and just in referencing the other associated documentation we've received, I want to thank you all for those. They will all be very helpful in our deliberations prior to the publication of our report. And in that context, I just want to thank people who are not coming before us in terms of the sequence of hearings, but are taking up the opportunity to submit their views on this very important subject. Now, I have a number of indications: Deputy Donnacha O'Leary, Deputy Jim O'Callaghan, Senator Francis Black, Deputy Mick Wallace, Deputy Jack Chambers, and Deputy Peter Fitzpatrick. So we're all on board, and we'll start. Donnacha, you have the first today.
I want to thank all the speakers for your attendance here, I think that this is the start, I hope, of a valuable process, something that will allow us to consider where there have been failings and how we can map out a better system. And I would like to think, and I think many other members of the committee would agree, in in the longer run, a radically transformed system, I believe. I think that there has been significant failings in the direct provision system in the way that we've treated in this country. People have come here fleeing war and persecution, and in many instances, their human rights have been failed very significantly, and many of them have suffered great hardship. Some of that is in the context, as I suppose, of all the statements have identified, in the context of the delay and the inordinate amount of time that people have spent in the system. But I suppose there have been other failings too. And I suppose just to start on the delay issue, like, I mean, that still seems to be, I suppose, a very stubborn problem, really. Like, you know, that there still is the IPO still only processing more or less the same amount, or even slightly less than what is coming in. Like, I mean, is the solution to that simply a resourcing issue? Is there simply not enough staff attached to the IPO to adequately deal with, I suppose, not only the backlog, but the number of people that are there? I want to ask, I suppose I have a number of questions that are general enough to an extent, but I suppose I would ask the question, and I know that the McMahon report had a relatively specific remit, but I want to ask all the groups and Dr. McMahon to, like, I mean, have you, and I think the Immigrant Council submission touches on it, is there a view that, or is there any sense that, like, the model that we have chosen, which is a model provided privately through contract, is a very flawed model, and that it would be better, given that, like, I view this we're before the Justice Committee, but in many respects these are accommodation issues and these are housing issues, and these people, I suppose, these asylum seekers who in the long run, many of which will become long-term residents in Ireland, many of them become Irish citizens in the long run, will ultimately have to be housed. Would it not be a better approach to provide accommodation for people directly, publicly, whether that's through, as I say, the Immigrant Council has touched on it, whether it's through voluntary housing agencies, whether it's through local authorities, whether it's through direct build of other kinds? Would it not be a better approach, particularly like when you take into account what direct provision has cost? Like, I mean, obviously the most significant element of people's criticisms and concerns of direct provision is, as I say, it's significant human rights failings. But like, direct provision has cost over 1.25 billion, I believe, since 2001. And for a parent and 2 children, it costs 40,000 per annum, roughly speaking. Like, that's actually more expensive than it would cost for many other forms of housing, if you want to look at it as a housing issue. So I suppose they're my first 2 questions in relation to the resourcing of the IPO. But secondly, should we be looking at a different model that is more either directly provided publicly or through some sort of voluntary community sort of
Thank you. Thank you, Deputy. Dr. McMahon, would you like to commence just with your response? And then
well, on the
processing,
sorry, I beg your pardon. On the processing, thank you, Mr. O'Reilly, for those questions. On the processing, there are areas of possible improvement, but it does seem to me that the authorities now are coping with the new applicants coming in. They're roughly dealing with 3,900 a year when 3,600 this year are coming in. So the present system would be fine if you didn't have what we call the inherited problem from the old system. There are a couple of pinch points. I think resources have been put in, extra resources have been put into the IPO and IPAT. One area where there is a delaying factor is judicial review. And there, I would recommend, I draw attention in my paper to that. There should probably be more judges dealing with the judicial review to remedy that area, because that holds up the applications in an area where we have no control, or the government has no control. It's a judicial matter and they're dealing with it. But I think that if more judges were dedicated for a period of time, you might loosen up some, make some progress there. With regard to other systems other than direct provision, you're absolutely right. The working group was had its remit confined to improvements in direct provision, so we were not asked to look at other alternative models. I am aware, I am not an expert in alternative models around the world. I have investigated and have been at seminars where discussions were taking place in relation to Scotland and Portugal and other countries. The problem as I see it nowadays is that other models, and I would have to be convinced that other models would succeed better in our economy with the accommodation crisis that we have now. Because if you don't keep people together, you've got to put them into other areas. So the accommodation issue is a serious, serious limitation on what a government could do in terms of alternative models. I would have to be convinced that another model, could work in our given situation with the accommodation crisis. And that it would be cheaper. I don't know it would. I haven't seen it. So work would have to be done to convince me that what we have would be better if we would shift it to something else in these difficult times in accommodation in this country. That's my own personal view on that. But I'm not an expert, and there may be models out there, and someone might do excellent research on it to show the government. But before you jump for what you have, given in particular the improvements that have been brought about in the 4 years that I've mentioned, it's not as bad as it was 4 years ago. In no way is it as bad. One of the suggestions that I make in my program is that the state is probably in a better position than anyone to provide more accommodation, build them themselves if they need to, on state-owned land, rather than going out to the market and competing in a difficult accommodation situation. But that's only a suggestion. I'd need research.
Thank you, Dr. Ivan. I had indicated just that I took Brian and end in that order. I'm going to juggle you up as we go along. If you're happy to come back to Deputy O'Leary's.
Yeah, absolutely. Thank you very much. I suppose in terms of processing times, our primary experience, as I mentioned in my opening remarks, is in relation to victims of trafficking who are within direct provision system. And it is a kind of a peculiarity in Ireland that we have what we call non-concurrence, that you cannot be an asylum applicant and be identified as a victim of trafficking at the same time, which is unusual in the international context. It's either one or the other in the Irish system. So somebody who's in the asylum process may be a victim of trafficking but cannot be identified as such, and someone who's a victim of trafficking living within direct provision cannot apply for asylum. They cannot be both things, which is unusual, but an important point to make. But in terms of the overall identification...
Sorry, just because while you're on the point, but before you move off it, predominantly the person who qualifies in both categories, who's an asylum seeker and who's a victim of trafficking, what are they recorded as primarily?
In general, if they are seeking identification as victim of trafficking, it would be to be identified as a victim of trafficking through the national referral mechanism.
Yeah, perhaps I could respond to that. It will depend on how the person has come into the system. So a person may have lodged an application for international protection and then subsequently been referred into the national referral mechanism and been provided with advices and seek then to be recognised as a victim of trafficking. And at that point, they are then faced with a decision as to which system may or may not suit them better. But in either event, they will still be accommodated in direct provision. And as Brian was saying, our focus is on the victims of trafficking who are being housed in direct provision.
I think it's fair to say, in terms of the process then of identification, that the cases that come to the Immigrant Council involve cases where identification can often take up to 2 years, and in some cases we, as a law centre, take judicial review cases of this complicated and long processing time of being identified as a victim of trafficking, which involves civil authorities, involves the Gardaí Protective Services Bureau, it involves the Gardaí National Immigration Bureau, and often that process breaks down in that time. So in our instance, what's needed is a much clearer identification process of victim of trafficking that doesn't involve so many different bodies as it does at this point in time, which allows for the quick identification of victim of trafficking. Because if somebody gets to the the stage of getting what's called a temporary residence permit. Once you're identified as a victim of trafficking, you get a stamp 4, which is a residency status in the state and allows access to support services. That's on the whole taking an extremely long amount of time to happen, but should it happen, that person could in theory then leave direct provision and go and live independently, as they would be able to be supported. So in our cases, yes, it's a mix of resources, but also a clearer identification process for victims of trafficking who are living in that system. In terms of the model, as I say, I speak primarily to our area of expertise, but internationally there are many models of housing victims of trafficking which, as I say, take a gender-based violence approach to it. So they rely upon women's refuges and they rely upon support services such as those to provide accommodation, both in an emergency capacity at the initial instance of somebody being identified, and in the long term then through the model of, say, approved housing bodies or voluntary housing associations which rent private accommodation and house victims of trafficking in that regard. Obviously, in the current context we're in regarding the housing situation in Ireland, that is very difficult to do. The housing bodies themselves are in a difficult circumstances. The refuges are oversubscribed as it is, so it does take additional resources for this to be a realised model of accommodation for supporting victims of trafficking coming from situations of sexual exploitation. However, that needs to be the point, the goal to which we work. That needs to be the guiding light to which we kind of aim our approaches, because, as I said in my opening remarks, the housing of victims of trafficking within direct provision systems in often cases adds to the trauma, adds to the essentially the continued difficulty of that person recovering from the situation they've just come out of. So while we recognise the context we're in, that needs to be the gold standard to which we kind of aspire.
Thank you. Deputy, in relation to your first question, the allocation of resources to the IPO in particular is always, of course, dependent on competing resource requirements within the Department of Justice and Equality more generally. I think it's difficult for external parties to say more than that, but one point I'd like to make is that when we drafted the McMahon report, we tried to be proactive rather than reactive in terms of planning for the future. The financial model developed for that projected new applications for last year as slightly higher than the number that actually came in. So the number of new applicants was predictable and could have been planned for. The report recommended front-loading of resources to put the priority on processing rather than reception. And it projected that would result in savings of 25.7 million in 2018 and 51.9 million in 2019. However, the situation we find ourselves in now is that 3.4 million was actually spent on emergency accommodation this year alone because of insufficient reception capacity. Moving on to your second question, I think without talking about a completely different model, it's important to acknowledge that the system as it stands today is actually quite different to the one 20 years ago. In many ways because of the implementation of the recommendations of the report. Two significant things I'd like to flag is the fact that it's been put on a statutory basis through the Reception Conditions Directive, which includes the right to work. Secondly, draft standards have been agreed with officials at the Department of Justice and Equality. It just remains now for the government to sign them off and for them to be implemented. So I would say that we've done an awful lot to ensure that minimum standards have been defined in law and also that they have been set out in standards to be applied in providing accommodation. The next logical step in that is to review the actual operations, to review the tendering process and to see how that can be put into practice, how uniformity can be guaranteed across the system. And I note that officials were in before the Public Accounts Committee last month and that they flagged that a regional tendering process will happen this year. I would recommend that the Department take a very open approach in consulting all relevant parties and that tendering process, a lot of effort go into that to ensure that it's truly fit for purpose and flexible enough to allow for alternative models. So if the standards are clearly defined, there's no reason why smaller accommodation units clustered in a region, for example, could not be part of the solution. And in the paper that should be before you on measuring outcomes, and supporting refugee integration. What I try to set out there is that there's a lot of government policy already there that can be implemented in this space. And really one of the key challenges is that the Reception and Integration Agency is responsible for procuring accommodation. It's not an agency and it doesn't do integration. It is limited in its role. It's dependent on the Department of Health, Department of Education, other agencies and service providers to link in with them and to provide those services around the accommodation centres. So really what you need is sufficient coordination and authority to do that coordination piece and to link in with all of the other departments.
Thank you. And Deputy O'Leary, have you further questions? Are you?
I do. I just want to make it brief.
Could I just suggest, it's only just that there are 6 colleagues all wanting, if we ask the question of all the groups, maybe occasionally it could be, and I'm saying this not just to Deputy O'Leary, but specify who you would wish to reply, that it isn't just across the board, because the time won't accommodate all of that for all of you. Please.
Yes, Chair. Okay, no problem. This is my final contribution. I just want to respond briefly to some of those and then ask just a short series of questions. Firstly, I take on board the point. Undoubtedly, the accommodation, the housing crisis is a huge consideration here, and I suppose that is something that affects every sphere of life, and it affects those who have got their papers and who are in a position to apply for local authority housing and to get HAP and all the rest of it. But there's nowhere else for them to go at this moment in time. But, we are, as I say, I believe this is an important piece of work. If we do it right, we do need to take a view that is right out into the future, to a future, I hope, beyond when a housing crisis has abated. I do think we need to take that view. We need to aim towards the best possible system. And I would say this, and I say this to the members of the committee as well, direct provision, and there are improvements that may have been made in terms of self-catering and the right to work, which I think is very important. But just to speak frankly, the words direct provision, it's my view that not only have asylum seekers lost confidence in the system, the Irish public has lost confidence in the system. The Irish public views direct provision as a dirty word. People feel ashamed of it, embarrassed of it. And I know people might have different views of what the reality of direct provision is like, but that is the perception in Irish society. And there is a feeling that people's human rights have been breached frequently and are being breached frequently. So we have an obligation, if we're going to map out a report here, not simply to look at incremental changes. I think we have an obligation to map out what is the best possible system that Ireland can deliver to receive people who are fleeing war and conflict and destitution, and to ensure that we treat them with the dignity that they deserve. And I think that's it's probably a very ambitious objective, but I think that is the objective that we should be pursuing. I just want to, I suppose, finish off just with a few brief questions. Firstly, I suppose one of the points that has been made in relation to direct provisions is the point in relation to their location, and it was made in the context of, obviously, asylum seekers. There's many appointments that you might have, most of them generally speaking in Dublin, but even some of those, I suppose, recently identified. Movil is 10 hours to get to Dublin, and involves going into the 6 counties, which isn't obviously permitted, strictly speaking. Lisdoonvarna is a one-day trip. It's possible to do it in one day, but you only have a very short period of time in Dublin. Kenmare is likely an overnight trip. The Mount Trenchard doesn't have public bus access. So obviously, I wouldn't necessarily be of the view by any manner or means that all direct provision centres should be in Dublin, but there has to be a balance to be struck, surely, in terms of either that as much as possible the services that people require in Dublin are, I suppose, brought to people where they are, but also, surely these centres should be located in places that are reasonably easily accessible by public transport. I think that's a fair expectation. A point that was raised previously as well is people who are in direct provision centres and leave direct provision centres, either find their own accommodation or stay with friends and things like that, and then find themselves homeless and seek readmission to direct provision centres that haven't actually been in a position to gain readmission, which I think is a problem that has been identified. I'm not sure if it's the Immigrant Council or the Refugee Council. but that is a problem that has been flagged, and I think it's been said that it's probably contrary to the recast directive. And then I suppose just a final question, I suppose I directed specifically to Enda, like, I mean, is it possible to predict, I suppose obviously it's extremely difficult, but is it possible to predict trends over the coming years, and particularly in the context of, do you expect, if there is either a Brexit with a deal or a no-deal Brexit, is that going to have a significant impact on the number of asylum seekers seeking asylum in Ireland? So they're all my questions, and thank you very much for your time. It's much appreciated. Thank
you, Deputy O'Leary. Enda, would you like to start off, and we'll give each of the contributors chance?
I'd just make a limited point in relation to the location of reception centres. I would agree absolutely the transport is essential in terms of people being able to go to the shops as a local town or access the services they need. Part of the Reception Conditions Directive, one of the things it introduces is a vulnerability assessment. Now, that is a new process, and we still have to see how it will work out in reality, but that's been incorporated into the standards as well, and the intention of that is that upon arrival people would be assessed in terms of their reception needs. That would include access to medical services, counselling services, and things of that nature, and that as on an ongoing basis that there would be someone from a social care background in each reception centre who would be tasked with ensuring that that assessment is up to date and that no new identified needs have not emerged since then. So you could imagine that system working quite well if it was developed in cooperation with other service providers and departments along the lines of what Judge McMahon indicated earlier, which is access to employment, but also mental health services, specialist services, counselling services, and things of that nature. That isn't happening in any systematic way at the moment, but it is in the legislation and it is in the standards, and we would hope that that becomes a very important part of the system into the future. Something else to mention on that note is that with dispersal, you could see more relocation around the country in terms of interviews for asylum applicants. Not all of the services have to be centred in Dublin, and we've had some indications recently that asylum applicants can be interviewed in Tipperary, and I think they're looking at Cork at the moment. So there are ways to ease the burden on people living in those locations as well. One thing I would say, however, is that in the resettlement domain, there's a task force at the national level which has representations from each department. There's also an interagency group at the local authority level, and there was an agreement in 2015 more or less in relation to dispersal around the country and the numbers that each local authority area could expect. You don't have the same process replicated in this space, and I don't see any reason why those type of structures could not be put on a more permanent footing, but also include both resettled refugees and refugees that arrive spontaneously here, so that there is appropriate planning at the local authority level and cross-departmental level to ensure that where people are located, that they have access to adequate services. In relation to predicting the numbers, I mean, in Ireland, really, we're quite fortunate from that point of view. We're not that easy to get to in terms of European countries. We're at the end of the line in terms of a lot of migratory routes. So the numbers have been fairly steady over the last number of years. In relation to Brexit in particular, we do sometimes see secondary movement from the UK, and that's something that is harder to predict. The Dublin regulation is the law currently that regulates which country has authority or has responsibility for the determination of an applicant's claim. That's a piece of EU legislation. Exactly what happens to that in the aftermath of Brexit could have a big impact on that question, and at present we don't have a clear answer on that.
Thank you. And Dr. McMahon, would you like to?
Yes, quickly. I won't repeat what Enda said, but I agree with most of what he said. Location of the centres is a very important factor. And it's very important for the availability of work, but also it's important for the equality agenda. to be placed in a location maybe in North Cork or West Mayo might make it much more difficult for a person to be gainfully employed and work than someplace near a centre of tourism or an urban centre. So that is a fact of life. It didn't make the same impact when the right of work was denied to everyone. But now that the right of work is available, proximity to the work is in fact. Now, it should be remembered, of course, that we have full employment in the state at the moment. I heard this morning on the radio that the unemployment situation is down to 4.6, which economists tell us is full employment. So there's no shortage in the economy of jobs. It's where they are. I agree with you also that the location is very difficult for people when they have to come to Dublin every so often for interviews and meetings. In particular, we've heard stories of where single mothers, for instance, who had to come to Dublin to do an interview, had to take their children out of school at the same day and travel up on public transport on very limited resources to do it. So I agree with you insofar as you implied it, and what Enda said, that there should be more interviews done locally in these cases. Predictions, who knows? I drew attention to the changes that have occurred in the world since 2015, the 4 years. But having said that, the figures we predicted for this year were an overshoot. We predicted that more people would come here than did, in fact, come here this year. So I think the points that Enda is making, we should get over the idea that everyone who is dislocated of the 68 million people in the world want to come to Ireland. It may be a last resort for them or a first resort. And insofar as what you said, I think is true, that the view of the Irish public about direct provision is, as you stated it, I think that needs to change now. I think in the 4 years, people would want to review their system. You'll still have people against direct provision as a model, but it's not as bad as it was, and it's a good deal better than it was. And I think that should be said. And what is the alternative? To quote the politicians, we are where we are. And if you can get me a better model at the same money, I will certainly approve of it. But
this is what this is about.
I beg your pardon?
I suppose that is what this process is about.
Yeah. And we need to monitor it every year. We suggested in the working group that there should be a body set up to monitor the progress. It's not perfect, and there's a lot to do. It could be, but we've made some progress.
Thank you for that. And Brian, would you like have you anything just further to add? Not to repeat.
Very quickly, no. I suppose just in relation to the location of victims of trafficking within the direct provision system and location issues, it is a shared issue that victims who are within the direct provision system are located throughout the country in different places. Approximately maybe half of the current identified victims within the system being within direct provision, and the location of support services built around that person is of huge issue. I think just to very briefly make the point concerning, I suppose what Judge McMahon said as well in terms of annual monitoring of asylum trends and generally migration trends in general. I think it's probably fair to say, although it may be a generalisation, we have to a large extent reacted to migration in Ireland over the last 15 to 20 years. We have to get to the stage of planning for it and investing in it. So questions that may come up, whether it be which next conflict outside of the European borders may put pressure on Europe in terms of accepting asylum applications, or whether it is issues such as Brexit, we need to not be surprised by these issues when they come up. We need to have mechanisms in place to allow us to plan and appropriately invest in our migration and integration systems going forward, so that we can actually respond to these things appropriately and be prepared rather than kind of, I suppose, reacting all the time to migration. So that's where we need to get. We need to get off the back foot, and we need to get into the situation of planning and investing for migration in Ireland going forward. And that's different than our current approach, although I recognise all the improvements that have been made. Thank you,
Brian. Thank you, Deputy O'Leary. We're moving on now to Deputy Jim O'Callaghan, but before I do, if I may, Senator Black, I had a request from Deputy Mick Wallace would you consider, and you could indicate to me that he might be taken just before you? He has a number of pressing matters to address.
Of course.
We won't allow canvassing, of course, but most anything else is permissible. Deputy O'Caoláin, please.
I'll be very brief, actually, Chairman. First of all, I want to thank you all for coming in this morning. I only have 2 questions. The first is to Caroline. In fact, Caroline, I know you didn't speak, but I read your paper, which was very informative. And one of the things you say, which is a remaining priority, is the establishment of a designated and independent body responsible for the oversight of reception conditions. Obviously, that was recommended by Dr. McMahon, but do I take it that you still think that is something that is essential?
It is essential. When the standards are implemented, there really needs to be oversight to make sure contractors are implementing those standards.
Okay. I can ask you, Brian, in terms of that, do you think that would be of benefit to the victims of trafficking and women who've been sexually abused who find themselves within the direct provision centre to have
Brian with an eye, I think.
Oh, yes. Okay. Yes. Yes, I think there's a third strand in relation to Ireland's response to victims of trafficking, which has been addressed at an international level and a national level as well, which is an independent rapporteur for trafficking in Ireland. So there have been calls for that both from ourselves, but from Greta and other international kind of expert level agencies. A rapporteur such as the Children's Rapporteur that would have an overview of how the state is responding to victims of trafficking in general. So that would be one way of doing it in relation to victims of trafficking, but also I think taking into account the fact that there are victims of trafficking within the direct provision system, that kind of oversight is definitely necessary and would maybe then feed into the findings of a rapporteur who's monitoring trafficking as an issue on an ongoing basis. And I think that is essential, yes.
Okay. And just finally, Dr. McMahon, in terms of, I suppose, the issue raised by Donnghaile there about direct provision being seen as sort of a dirty word, that probably is true. Like many people seek to compare direct provision centres with sort of mother and baby homes where women were involuntarily incarcerated many years ago. Like, do you agree with me that it's important that the public is given an accurate assessment and presentation of what these centres involved, and also that there's an accurate assessment that the numbers of people seeking asylum in Ireland are very low by European standards?
Of course, it is important in informing the public that the information given to them is accurate. I don't know of anyone consciously trying to distort the situation, in my view. But certainly the McMahon group, the working group under my chairmanship, was very independent and very truthful in what we saw and reported it as we saw it. And I think since then, all those who participated in the system, certainly the NGOs and the individuals involved, have been very honest and open, as I have tried to be always. So I think a balanced, I think it's like anything else. When you give a dog a bad name, it will stick to it for a long time. Until the impression is reversed. And it takes a lot longer to reverse a bad impression than it does to create a bad impression at the initial stages. So I think that the message does need to go out there that the direct provision that was there 5 years ago, 4 years ago, is not the same as the direct provision that there is now. It's not as bad.
You think it's improved?
But definitely improved, dramatically improved. I visited too, as I said, in the last month, and I was told by the managers there that the right to work and the increased allowance has made a huge difference to the morale of the people in the system, and also that the processing time has shortened.
Okay.
So I do think that, in fairness to everyone involved, if there's a better model out there, someone should research it, cost it, and produce it, and bring it to the front. I don't see it at the moment.
Thank you, Deputy O'Caoláin, and with Senator Black's OK, I will now invite Deputy Mick Wallace.
Thanks very much, and I'm sorry I was late, but I was listening to Dr. McMahon on the monitor in the office, and just to be as brief as I can, just a couple of questions, and I'll direct them to you, Dr. McMahon, not to be dragging other people's time out. You talked about the fact that the system, as you're saying that there's been improvements made, things are better now, and they're handling OK the numbers coming in on a yearly basis, but the backlog is a challenge. what do you think of the idea of an amnesty for anyone who's been in it for over 5 years? My second question, I'm wondering, are vulnerability tests being carried out in any of the centres as a matter of course? And if this is happening, do they happen within the first 30 days as required by Article 22 of the Reception and Conditions Directive? And is there any provision of ongoing vulnerability assessment as per the regulations? My next question, we heard Minister Staunton tell us that the combined fully implemented or in progress partially implemented recommendations make up 98% of the total recommendations contained in the McMahon report. But a year ago, NASC disputed this claim, saying that at best 51% of the recommendations were in progress or partially implemented. What is the status of the implementation of the recommendations at present? And I suppose my last question, there's been rising numbers in emergency direct provision, and obviously the conditions are even less attractive than in the regular form. And would you have any serious concerns about that?
Thank you, Deputy Wallace. Dr. McMahon.
Right. I'll try to answer as quickly as I can. First of all, starting with the last question, the emergency. Emergency accommodation is not desirable. It's costly, it's not suitable, and it should be addressed as quickly as possible. No one should be in emergency accommodation. I think it costs €99 a night. Work out the math if there's 500 people, looking in accommodation at the moment. It's huge. We know that the cost of keeping a person in direct provision is $10,900 a year. Emergency accommodation, $99 a night. So that should be a priority. Emergency accommodation should never be. It has to be resorted to in extreme cases for short periods of time, but it's not a part of the solution, and it shouldn't be a part of the solution. I suggest that in that situation, given the housing crisis that we have in this country at the moment, that it might be the only way to address that might be for the state to build its own direct provision centres to house people in those situations so that there wouldn't be a need for emergency accommodation. The other problem on that front is that the properties that were available, disused hotels, disused secondary schools, in the present situation, these may no longer be available to the state for direct provision centres. They're probably becoming commercially viable again. And the builders and developers, you know more than this, hoteliers, might say, now the economy is such, we need, and we can make a go of these commercially. So there may not be that many of them out there. So in those circumstances, I think the state should look to see whether they should build themselves. I know Father McVerry and the Jesuits and other people have been doing a pilot scheme to try to get people out of direct provision and have been successful in that situation, but it's very small numbers. So that's the emergency. I'm totally against emergency. It's unsuitable, it's costly, and it's a last resort. Amnesty for 5 years plus. We tried very much in our discussions to introduce something which looked like, which was like an amnesty, but we didn't dare call it an amnesty. The politicians could not live with amnesty, because amnesty is not a kind of a prospect that would go down with the public. So the word amnesty is to some extent taboo in this discussion, because it will not fly. You can deal with, as we tried to do, and as the administrators did, they did try to do it in another way, on an ad hoc basis. You can't say we'll give amnesty to 4,000 people, but they did say we will prioritise them, we'll look at them quickly, and we'll be a bit more lenient, perhaps, be a bit benign if they're in the system for 5 years. So it had to be done without using the word amnesty. But there's no doubt about it. People in the system for 5 years or more deserve compassion and quick treatment, however you call it. The second question you raised, I think, was about the assessment in Balsiskin. That's, again, another result of the accommodation crisis. Balsiskin is the initial reception process, where it's the first place that applicants come to when they reach this country. There they are medically assessed, they're legally informed, and they come in touch with the system. And in recent times, it is my understanding that Balseskin can't take all the applicants, and so they are put into emergency accommodation before or during the assessment period, and that is unfortunate, and that should not be allowed. And I do think that the department is taking some steps in that regard to expand Balseskin so it will accommodate everyone. So they will get their initiation training, and will be the initial assessment, both legally and medically. That's very important when they come to our shores first. You asked me about a statistic that was thrown out that 98% of all recommendations are implemented. I don't believe it. I can't say that it was 90% or 85% or 50%. I don't know. A lot of them have been implemented. The important ones, some of the important ones have been implemented. But when there's people throughout, I know it has been disputed by some of the NGOs that 98% is not true. And in fact, if you look at the cooking facilities we talked, the department itself says that they have cooking facilities for 38%. So that there's 62% who are not getting the cooking facility. And on the cooking issue alone, they're not getting the independent living in the cooking. So I'm not going to challenge a statistic like that thrown out. It's too general. I don't have enough specific information. If it's more specific, I might be able to respond to it. But I give you that for what it's worth. But some of the NGOs did not agree with the general statement that 98 of McMahon recommendations are implemented.
Thank you, Dr. McMahon. Deputy Wallace.
Just one last question to end on the issue of the vulnerability test being carried out at the centres. Are you happy with that?
Frankly, the situation is not entirely clear. We do know anecdotally that it's been done in some cases, it's been done in request. There's certainly been some positive developments on that of late. However, it's a new process. When we ask the Department of Justice, they often tell us that they are continuing discussions with the HSE, and I would say that it is under development, but I can't say with any authority the extent to which it is done in every case. Judge McMahon alluded to the fact that not everyone was able to go through Balseskin, and there are certainly some good facilities there in terms of medical assessments and things that are happening there. If you can't go through Balseskin Registration Centre in the first instance, you can't access those. One measure that we have been trying to employ to counter that is Safety Net uses mobile health screening. And I know that that's been a very useful service for people who've been able to access that as well. So there's plenty of work happening in this space, but at the moment I think the situation is still evolving.
Right, thanks very much for all the contributions. Thank you.
Thank you, Deputy Wallace. I wish you well. Good luck.
You've already seen the back of me, are you?
We'll talk about that. We'll talk about that after you've left.
I still have to get elected, don't I?
Anyway, there we are.
Thanks very much.
We'll say no more for now. Senator Frances Black, please.
Thank you, Caoimhghín, and I want to thank all the witnesses today for your presentations and for the work that you do. This is a huge, I suppose, concern to me. This topic is a huge concern to me, and I'm really glad to hear Dr. McMahon say that the situation has improved over the last 5 years. But I still find it very depressing. I still find it very sad and heartbreaking. And I suppose I would like to ask you, Dr. McMahon, I suppose about the right to work. That's the first question anyway. And, this has been highlighted by direct provision residents and campaigners for decades, and as well as the working group in 2015. And I know we saw the Supreme Court decision in 2017, which I strongly welcomed, and that effectively forced the state into some action. But I don't believe it's nearly enough. And residents raise issues regarding access to bank accounts, driver's licence, and the remote locations of many centres, making it impossible to work. They're still prohibited from many unprotected industries and jobs with certain pay. So And estimates say that only some of the residents are working, as you mentioned. But because of this, it seems we now have a limited legal right to work, but not an effective right to work. And would you agree with this, Dr. McMahon? And is there a positive obligation on the state to actively ensure the right to work is actually accessible? So I just wanted to know what your thinking was on that, and then I want to come to maybe yourself, and I just want to, I suppose, ask you a little bit about the lack of common quality standards in the centres, and I know we've touched around the cooking facilities. And the ability to prepare a meal for yourself and your children. I mean, it's such an important, it really is. I mean, that is, for me, it's just basic dignity and respect. And, you know, those who can't cook are infantilised and denied the chance to make basic decisions about what they will eat and when. So, would you agree that there should be a consistent set of standards across every centre? And do you think that the opportunities and rights should be afforded to every applicant equally? And could you elaborate a little bit more on the standards being worked on at the moment? So, and then I have a couple more after that, if that's okay.
All right, well, we'll take Dr. McMahon first, please, as that was the first question. Thank you.
I agree with you that we should ask the question, just because people have the right to work, whether it's an effective right to work. And I did advert to that in my paper. A couple of things that I have come across are, first of all, opening a bank account. Simple thing you would imagine. But local bankers seem to turn their face against anyone from direct provision centre. They don't seem to willing to accept the addresses to open a bank account. And I know that there are certain anecdotal evidence that people have tried and failed. I also know that I have anecdotal evidence to the contrary, that in some cases, some bank managers are a bit more human and humane, and if some sponsor goes in with them, they may get the decision. I have raised this myself with the Minister as something that should be addressed at central level. I don't see why the Minister or someone at that level can't talk to the banks generally. You're talking about 3,000 people, you know. Yeah. It's not a huge amount. And if there is some controls to be put in because of bank laundering and fears of that, I'm sure they could be agreed with the direct provision people. You know, so I agree, it's a big issue, because a prospective employer, if he sees any obstacle at all, will use it to turn an applicant away. If his payroll has 100 people and they're all paid by a bank draft or a bank transaction on a Friday evening, and this person, male or female, comes in and says, I'm in direct provision, I don't have a bank account, will you give me cash? The employer will say no. Yeah. Just because it's difficult and an additional obstacle, and why should I get involved in that kind of... Similarly with driving licenses. Again, that should be tackled. Centrally, there is no reason in the world while that this should be any different for people in direct provision. Some of them are driving, I know, so they must get away with it. I don't know what the position is fully, but I do know anecdotally that they have difficulty getting driving license. And if you're living in Mill Street or in Portlaoise and you get a job in Tralee or in Listowel or in Limerick, how are you to get there? So it's an ineffective right. So those are two examples that are there and should be addressed. They should be simply resolved, in my view. And I do know that, and I'm not telling tales out of school, that the Minister of Justice has spoken to the Minister of Transport on these issues, so it's been kept alive. With regard to the location, I've addressed that already. The location of some of these centres militate against getting a job. If they're 6 or 8 miles out of the country, away from a town, and the transport is limited in some of these countries. I know centres where, would only have a bus once a day, and the bus goes to the school and comes home after dropping the kids and collects them at school, and there's no other transport in and out, unless you have a bicycle or something. So I would like to suggest to the authorities that when they're picking a new location, if they have a choice of picking a location, near an urban centre or near an area where there is work available, that they would consider that in making the choice and put it into their procurement process.
Thank you. And there were further questions for you too, please.
If I could just make one small point on the latter question as well. I think sometimes questions like the implementation of the right to work, that can become politicised, and sometimes the debate is quite polarised and anecdotally based. I think really in terms of all matters of serious policy development in this space, I'd refer to the Department of Justice and Equality's own culture and values charter, which says that they approach policy development in a spirit of openness and consultation with all relevant stakeholders and employing evidence-based policy methodologies, which is also in their strategy statement. I mean, that's what we did in the McMahon report in the working group, and we were given the information and the evidence in order to be able to make well-informed decisions and to speak with all the relevant departments and to frame policy in that environment. I'm not sure that I can say the same thing is happening on an ongoing basis. I think that's one example of an area where we should always review and see if it's effective and whether more can be done. And I would give one positive example, which is the Open Doors initiative. So there's a number of government departments and the private sector collaborating on that, and a number of NGOs and ourselves are supporting partners. And we helped contribute recently to a support tool for employers so that they can better understand the permissions and understand how they can go about employing people from various backgrounds, so migrants, refugees, asylum seekers, persons with disabilities. And I think we need to encourage constructive spaces like that where we can all play a role to try and find solutions rather than maybe throwing figures around that we're not sure of or finding criticism when we can maybe find solutions. So on your second point in relation to the standards, there was a meeting last week with officials from the Department of Justice and Equality where the final text was agreed. There was a public consultation, so I'd like to credit the department. I thought it was very positive, the initiative that they took to that, and ourselves and a lot of the NGOs concerned and officials from the department went to the various centres and met with residents and discussed the standards with them. So I understand that the final step is for the Minister to sign off. I would expect that to happen promptly. Those standards have already influenced the contractual basis of some of the current arrangements with direct provision centres. I think the best way to understand the standards is that they translate the recommendations of McMahon into easy to understand binding standards that will apply universally to reception centres. There's certainly a potential issue with the divergence in standards across the system. Even within centres themselves, there can be complete divergences of standards between the rooms for families and single males, for example. So with these standards, there will be uniform treatment, but of course, in order to ensure that they're applied in practice, an independent inspectorate is required. So they will form the basis of contractual obligations with any provider of services, and it's crucial that an independent inspectorate is given all necessary authority to go into centres, unannounced, and to have all the powers necessary to be able to say with authority that they are in fact being implemented in practice.
I agree with that.
Yes, please. Yes.
Independent outside body to monitor is important, is very important.
Brian, Mary, Maria, Eddie, if you would like to add anything at all at any time, just indicate. You're very, very welcome. Maybe I'll go back to the Senator who had some further questions.
I have a few more questions, if that's okay. I just want to talk a little bit about, I want to hear what you think about private operators. In 2018, the state paid $72 million to private firms operating direct provision centres, and many of these firms are through offshore companies, meaning secrecy and a lack of information on how much profit they're making. So it just seems incredible to me that private companies are allowed to profit off extremely vulnerable people, and quite upsetting actually. When the profit motive is introduced, the concern becomes a lower bottom line and not the welfare of the people involved, and that's my concern. So If the state is responsible for the welfare of residents, then should it be outsourcing this function to private companies? So that's the first question I'd like to ask you. And then I just wanted to ask, sorry about this, Caoimhghín, but I just have another couple of questions. I also want to ask about the likelihood of legal action against the state. You know, we know that Ireland's Rapporteur on Child Protection has called the system of direct provision state-sanctioned child poverty. And asylum seekers themselves have spoken about the misery endured within the centres and how their humanity has been slowly taken away and fundamental rights ignored. So I'm just wondering, I mean, I believe this could possibly result in another state apology and redress scheme in the future. I mean, 2 weeks ago, I spoke at an event marking 10 years since the Ryan report and the abuse inflicted on people in industrial schools. And, you know, I am concerned. I'm very concerned. So is there potential for the residents of these centres to take further court cases now or in the future? And can claims be made that basic constitutional rights or rights outlined in international human rights instruments are being violated? And particularly, I just want to highlight, I find I suppose, Brian, what you talked about, the victims of trafficking, I find that extremely upsetting. And, you know, it's shocking to hear that there's no services there for those who've gone through such horrendous situation, and to think that they're, you know, almost left there in a state of post-traumatic stress. It's just so upsetting. I mean, I find it even hard to hear, to be honest with you. So I wanted to ask you, I mean, firstly, I wanted to ask you, you know, what do you think, what would you like to see done in that area? And another question I wanted to ask you is, why are they asked to leave after 60 days? That really kind of stuck out for me. What is the reasoning for that? So, thank you very much, Caoimhghín.
Question at the start?
Possibly Dr. McMahon, if that's okay.
Here we go. Thank you.
Private firms, overseas companies, non-transparent profits. Once the state decides that they're not going to do it themselves and they engage outside commercial bodies to provide the premises and to run them, you have that problem. They have to be paid. The question of the transaction and the transparency of it, in my view, should always be transparent. I don't know how little one is known. It seems to me that those figures are available in general. How much profit they're making, I don't know. I am not privy to that. There's a certain amount of confidentiality in these transactions. I'm not sure it's secret to that extent. But once you do an outsourcing job, that's inevitable that you'll have a commercial deal. Now, the outsiders will not do it unless they're getting a reasonable profit. And the question arises, what is reasonable and what is not reasonable? The suggestion that you're making is that they're exploiting the opportunity. I don't know that. That's a value judgment. I don't know that, but I think there's a lot of people looking at this exercise now, and I suspect that it's less than people might say sometimes. I don't know. But it's a relevant question, and it's a question that might arise in terms of value for money. Are we getting the best value for money, or would you be better off if the state went off and did this themselves? In the the accommodation crisis that we have, I am suggesting, and I have suggested to you, that at that point now, it may be a time for the state to say, well, we're going to provide some more new centres, because with the likelihood of getting commercial premises out there now is shrinking. So we may have to do it. So it would be probably better they'd control it then. Well, we hope they'd control it. Who knows? But if they start doing it themselves, they're in a position at least to have the job transparent. With regard to the likelihood of legal action, I have no opinion on that. I am a retired High Court judge, and I have ceased to think like a lawyer, and I certainly am not giving advice. But, having said that, the courts are always open to individuals in this country, as we have seen in the right-to-work situation. You can always go and plead your case to the Supreme Court or up along to the Supreme Court and get a judgment. But if you ask me, is it going to be like the residential institutions in the world? I don't know. I don't know whether an argument could be mounted to that effect. But people say that sometimes. And I suppose that from that point of view, the improvements have to be welcomed.
Absolutely.
Thank you, Dr. McMahon. Enda, please.
Senator, if I could just reply to one aspect of the question, the notion of outsourcing. I just want to ensure that it's clear to everyone that really what is outsourced through RIA is only one aspect of the direct provision system. So contracting accommodations, services and food and things around of that nature. When you visit a reception centre, often what you find is there's a range of services in the centre provided by, for example, the HSE or an NGO, or they rely hugely on other service providers and departments. So I think it's really important that those types of services and those departments are accountable for what their responsibilities are, and that isn't down in law under the public sector duty, under the Human Rights and Equality Act. So, under the guidance issued by the Irish Human Rights and Equality Commission, they are obligated to plan for and to provide reporting upon how they implement that duty. So I would say that all those aspects are not outsourced, and not enough is done to hold different departments to account for their provision of services and to ensure that sufficient coordination is in place so that when a new centre is proposed to open, that all of the other required services and departments can come in and provide those services.
Thank you. And Brian, please.
Thank you very much, Senator. And in particular relation to your last point about the victims of trafficking support, I suppose to clarify, it is not entirely the case that there are no supports provided. Through the National Referral Mechanism, which is the national mechanism for identifying a victim of trafficking and what happens to them once they are a suspected victim of trafficking, there is a model whereby access to health and support services can come into being. But I think what we see in reality is that there's huge inconsistencies in how that actually happens. So sometimes it does happen, and I absolutely don't want to disparage any of the services out there that do provide it, especially those that are connected to the HSE. But I think because of the identification process of victims of trafficking being so complex and often inconsistent, as I say, in some cases taking up to 2 years for somebody to be identified, we see inconsistencies in how that happens. So often this breaks down. And I think one of the significant issues is in direct provision centres and in RIA centres, the level of training that's provided to staff and managers in relation to the specific needs of very vulnerable communities, such as victims of trafficking, leads to that inconsistency. So often the staff and the managers themselves will have no idea of the particular instances of the person they're dealing with, and therefore the particular needs they have will often, they'll fall through the cracks within the system essentially. So there is a model there. There is a model that needs to be applied, but our findings, I suppose, is that it gets undermined by the identification process and it gets undermined by inconsistency as well. And as I say, the whole approach of looking at somebody who's a victim of trafficking from the perspective of being a particularly vulnerable person, but also the gendered nature of the issues that they're facing. So, for example, being in mixed gender hostels, being in a room with up to 4 people, all these contribute to the factors that already exist for somebody who's in direct provision. They compound again and again and again the trauma that somebody experiences, you know. And I think it is worth referencing that in the Department of Justice, there are many individuals and many key civil servants that recognise this. You know, it's not the case that there's a complete blanket denial of this from the department, or indeed from some of the politicians involved as well. But overall, we're in this institutional, repetitive nature where we're stuck with the approach we have. But I think there is recognition that we need to provide this ameliorated level of care, and I think we're obligated to do so by the directives we've opted into and by some of the pressure we're under from international instruments, and not least from the experiences of the victims of trafficking that are in the system as well. So there's progress being made, but it's incredibly grindingly slow, unfortunately.
Thank you, Brian. Senator, are you almost there?
The 60 days I just
Sorry, yes, I forgot about that point. The 60 days is in the responses to a victim of trafficking. There's different stages in it. The first stage is called a recovery and reflection period, which is essentially when somebody is identified as a suspected victim of trafficking, they get 60 days in which to recover initially from the situation they've just come out of. As you can imagine, somebody coming out of a situation or being exploited in the sex industry is dealing with immediate trauma, immediate often physical effects and psychological and mental effects of the circumstances. That often then can change into what's called a temporary residence permit, which is a 6-month permission. So it's the 60 days is the first part. What we see happening, and again this is anecdotal, we're hearing it from different services, is that some of the RIA centres are interpreting their obligations as being just that 60 days, that once that 60 days is reached, they don't have an obligation to the person. They're writing them a letter saying, please leave the centre. That person is going to the support services going, what do I do now? And the support service is going to homeless services with that person going, have you got a bed for this person tonight? You know. Now this, again, there's no piece of research that can identify this, but this is what we're hearing from the services, and we've seen it ourselves, and that's completely unacceptable for somebody who is just out of a very traumatic situation, you know.
Thank you.
Thank you.
Senator,
Thank you very much.
Are you okay?
Yes,
thank you very much indeed. Deputy Jack Chambers.
Thanks, Chair, and I'm going to be brief because I know a lot of the questions have been teased out, and thank you all for coming before us and presenting very comprehensive documentation. Just on the point that Senator Black made about the effective right to work and how I suppose there's a mismatch there between the apparent right and the actual effective right. Do any of you have any, I suppose, real-time information about what is actually happening with that? And are people getting jobs, getting work? Do you have examples of that, or you know, how effective is it just in terms of real-time information? Also, in terms of service-level agreements between these private contractors and the state, how specific are they around trying to oblige and improve the threshold of intervention around the various aspects, whether it's in health or proper accommodation, and how effective is the oversight mechanism there? And then on the, I know there's mention of a national standards for accommodation and an inspectorate being introduced to try and oversee that. Who would, I suppose, you know, who would run that, or who would operate it, and how effective do you think that might be? Because I'm aware that, like, particularly in this committee and others, we've got lots of different siloed inspectorates and oversight mechanisms which are then accountable to different bodies. Like, and as I come back to the original point of having, because it was one unified body or agency that actually deals with this in a more holistic way, and also on the healthcare issue. Like, you know, in terms of mental health and obviously people coming from war-torn countries. I know in my own area in West Dublin we have a lot of people who've gone through the process and are now out the other side, but the problem is it doesn't end there, as you all know, in terms of the healthcare you know, deficit and just the whole, you know, housing issue as well. So in terms of the after piece, do we need to oblige local authorities in a greater way, or even in terms of healthcare rights to improve the legal threshold there for people who come out of direct provision and are potentially accommodated? Like, how do we continually provide a kind of a rounded intervention for them as they progress through society? Because I know in places like, I know in Canada, for example, it does that in a really positive way at an early stage, and they see the positive effect for their society, whereas in Ireland we're kind of this game of catch up forever and for more means you know, the person behind the you know, difficulty is never given the chance, and I suppose that's what we all seek to. So just there's some general points, and thanks, Chair.
Would you like them directed in any particular sequence?
No, I'm happy to hear whoever has it. I know, I said, a lot of the questions have been asked and answered very, very well, and the
Would you like
evidence
to
is
take the
comprehensive. So
first?
whoever wants to say anything, yeah.
We'll start with Brian.
Thank you very much. I suppose there's a couple of ones I can maybe speak to a little bit, and your last point about local authorities being an interesting one. We do a lot of work with local authority areas throughout the country on integration strategies. So it's a standard practice, I suppose, at the European level and everywhere, that local government areas need a strategy through which to kind of identify a framework and indicators and goals and funding for how they are going to coordinate all their services at a local level, but also engage those services with things like health services, but also the private sector and also NGOs, support organisations, community groups in other areas. So it's quite a big thing, and it can be quite fluffy in terms of sometimes they you know, integration strategies often focus on things like positive integration initiatives and community events, which are brilliant, but actually a lot of it is down to the nitty-gritty as well of how you then absorb somebody coming into the community either newly or from a direct provision centre who has just come into the community having been in essentially kind of an institutional form of living for the last 5 years. So we'd work very closely with some of the local authorities, and we would urge them that if there is a direct provision centre in their area, they need to build that in as a strand of their local integration strategy. How they respond to that. Somebody who comes out of direct provision centre may not decide to live in the local community where near the centre. They may go somewhere else. They may go to a local city or somewhere where they have family. But they do need to take into account that that may be part of it, and that person may need ongoing support in terms of specialised assistance around employment or specialised health supports as well. The difficulty with integration strategies is while local authorities are encouraged to have them, they don't have to have one. They're not mandated to have one. So as part of the National Integration Strategy, it says local authorities should have one, but they're not legislatively required necessarily to have one. So you get a sporadic approach again, where some local authorities, like Fingal, for example, over the last 2 years have put huge resources into their integration strategy, and it's kind of a very complex and good one. And then there are other areas where really at the starting point going, okay, how do we start even an integration strategy now? And the funding often is an issue there. So local authorities will say, we don't have funding to do an integration strategy. We have to use our funding on the priorities, housing and education, and all the usual things that are there. So that again comes back to our planning around these things. So it's locating a centre in an area isn't just a once-off action. It's something that's going to reverberate for years and need to be built into the infrastructure of that area, and an integration strategy is a surefire way to look at that, you know. And I suppose the first question you had around right to work, while there is, I think it's worth pointing out that both in Ireland so far and at a European level, the tendency for asylum seekers who have a right to work is to go into self-employment because they face significant barriers in going into regular employment or getting jobs in areas. So while a large number of people have taken up the right to work in Ireland, I think it's unclear how many people are in self-employment and how many people are in actual employment. What we're hearing from those that are contacting our services and from our integration work are, as I said, bank accounts are a significant issue, although there is moves by some of the banks, both because they've been forced by recent court decisions, but also as well because they're recognising that this is something in the long term they need to sort out, to figure out what I suppose you would call limited function high-risk bank accounts. So the type of bank account that deals with the issues that they face of identification and address, but allows somebody a function that will satisfy an employer so they can be paid into an account. So there's movements in that area, and I think this year we will see some of the banks come out with initiatives that address that. So I think that's positive for a start, but at the moment it's still a significant problem. I think driving licences, we've done work with both the Department of Justice and the Department of Transport trying to figure it out. We get batted back and forth between the two, saying when it's the responsibility of the other. So as of yet, there's been no resolution of that issue. Location is a significant issue, and as Enda mentioned, the private sector involvement and level of knowledge about the right to work of asylum seekers is incredibly low. So we're trying to do work at the moment with the likes of the employer agencies and bodies to spread information about it. The likes of the Open Doors initiative that we're a supporting partner in as well, which is 22 large private employers doing special schemes and initiatives around employing asylum seekers and refugees are really important too. So there's positive things going on, but again, there's serious gaps in it as well, you know. So they're the two parts I think I can speak to anyway. Thank you.
Thank you, Brian. Yes, Dr. McMahon, please.
With regard to the specifics in the right to work, I have a statement here from the Secretary-General of the Department of Justice, and I'm quoting, approximately 2,300 applications for the right to work have been made, with 1,600 having been approved. We've had 632 employment declaration forms returned. So that would suggest that officially there's at least 25–30% of them being approved at the moment. I mentioned, I think when you weren't here in the chamber, I visited 3 centres in the last 10 days, all in the same area of the country. And in one centre, which was a men's only centre, 38 of the 57 were working. That's a good number. And of the 38, 3 were also doing further education. In the next centre, which was women and children, only no men in it, the 86 people were there, and I was told about 70% were working in that centre. Now, some of those would not be in a position to work because they had young children. So 70% of that cohort is a big number. And the third one, where there were single women in a centre, 70% again was given the figure of working. Now, I hasten to add that that was in an area of the country where there is a good tourist and where jobs, that kind of in the service, hotel service industry are readily available. So I don't know how common that is, but it's just in one particular area, those are the figures, and they are very encouraging. But I don't expect it's the same in Foynes or in Mill Street or in some of the other remote centres. But that's why we're talking about location. HICWA was mentioned as the standard authority that might be approached to do the job for direct provisions. I'm not sure that it was accepted or pursued as yet, but it needs to be an independent body who have teeth, in my view, somewhere. So the departments will be negotiating between themselves of whether, I'm sure there'll be a reluctance to set up a new agency, but someone else could maybe take it on board as part of their portfolio. Enda wants to say something.
Thank you. And Enda, please.
Just following on from that, I mean, I think in this area, almost every department of government is involved in some form or another, and I think the driving licence situation is a good example. What often happens is you're going between one department and another, and there's ongoing discussions as to whose responsibility is, and I mean, there's no referee, there's no one above that to decide. So it requires a lot of cooperation, and these things can often take a very long time to resolve. I think that conversation is relevant to the inspectorate as well. HICWA has been mentioned, but legislative change would be required. There'd be resource implications. So really, I think what we need is a new approach, an all-of-government approach to these issues. It's bigger than just the Department of Justice and Equality, and whether you have a rapporteur, like Brian suggested, or some other model where someone can have a bird's-eye view of the entire system, because we don't have performance benchmarks, baselines, indicators across each department so that we can see, well, what are you aiming to do? What does success look like? And have you made progress on those targets? So I think that's a difficult conversation, but it's one that needs to happen. The standards have been agreed at the department level, so it needs to be signed off now. And it's envisaged that there'll be a period of 2 years where the centres will be expected to come up to standard over that period before they become binding. However, that said, they have informed the tenders already to date. So many of the important aspects of the standards come from the McMahon report, and which in turn have been incorporated as some of the requirements of the tenders already done to date. And while we haven't had sight of the contracts with direct provision centres, this commercially sensitive, they are made available after a number of years, I believe. We did have an example, it's appendixed in the working group report. But the tender documents themselves do now contain quite a bit of detail in terms of the expectations of contractors and what is required.
Thank you. And Deputy Chambers, are you finished?
I am, yeah.
Well, thank you very much indeed for that. And our final speaker from the Justice Committee panel is Deputy Peter Fitzpatrick, please.
Well, first of all, thanks very much for coming today. I'm going to be real honest here. This has been a real education for me. This is something that I wouldn't really know much about. And I remember my mother told me years ago, if you don't know anything about it, don't be afraid to ask the questions. First of all, I want to know is there's approximately 6,000 people living in direct provision at presently, right? What statistics or what information do we have on these people that live in these accommodations? can you tell me how many's living government and many living on private as such? Like, and also, can you tell me what entitlements are these asylum seekers entitled to? You talked earlier on about qualified people living in these assignments. Like, you talk about people maybe having plumbers and carpenters and everything else at the moment. Is like, for the last few months especially, I've been contacted by a lot of contractors, painters, mechanics, electricians, everything else, with a massive shortage of workers. And they've been in constant contact with Minister Humphreys about the work permit scheme for taking people from other countries outside the EU coming into the country. So I'm basically trying to say at the moment is what information do we have on these asylum seekers? And I'll put my questions to Dr. Brian McMahon and also to Enda O'Neill. I have a question for you, Brian Killoran, later on. But if you just to me, as someone who doesn't really know much, I'm willing to learn. Can you educate me and tell me what's going on?
That's a straight-up request. Dr. McMahon.
How long have I got to educate you?
I want to help.
The first one is easily answered. There are 6,106 people in direct provision at the moment. 6,106. Indirect provision. Now, people can come into the country and be an applicant for asylum and not live in direct provision centre. You can see, if you can choose to live outside, if you have the means to live outside, you can do so. So there is an undefined number outside the system. I think when we were doing our report in 2014, it was nearly 50-50. There was something like 4,000 living in direct provision and 4,000, it was estimated, living outside direct provision. Now, it's very hard to keep tabs on the people outside direct provision. The figures are there. I'm sure Enda has them more accurately than I have, because they don't have to. They just have to apply their legal application, and then the next thing they're not seen until the next stage in the process occurs, and they're called to come before a tribunal or whatever. So they vanish, and it may be that some of them went to England secretly or clandestinely. We don't know. So there was a big question mark about how many were outside direct provision. But we were only asked to report on the direct provision people and what the state's obligation to those are. So that's why our focus is confined on that. I suspect nowadays that there's less living outside direct provision than there was in our time. That they're all in direct provision, or a lot of them are in direct provision now, because there's not alternatives available outside easily. You touch on a subject which is fairly complex about their willingness to work and their qualifications. We met people in direct provision who were architects, who were economists, university lecturers, as well as people who were tradespersons in their own country. Now, the question of recognising their qualifications is a big one, of course, and that applies not just to people seeking asylum, but anyone who has come to the country and wants to practice as an architect has to show that they're equivalently agreed. But there is a resource there. I suspect there is a resource there of people who could work, and particularly in the trades and in the country places. I'm not sure about electrician now, but there's work for everyone, we're told by the economists now. And if you come from a small town or a local provincial town, you would hear people complaining that they can't get someone to tend their garden, or they can't get someone to do handiwork or paint a house or whatever it is, which you would imagine might be in some direct provision centres. Someone else might, and the panel might know more about their skills and how they're trying to match up the skills in direct provision with the needs of the local economy. But that was not asked simply because they hadn't the right to work up to recently. Now that they have the right to work, and I'm surprised to hear that it's not that publicised in direct provision centres as much. That of course, is a crying shame if it's not posted in all these direct provision centres that after 9 months you're entitled to work, and that should be promoted And there's a role there for voluntary groups, local groups, community groups and a lot of these direct provision centres now have friends of the centre, you know.
Sorry, the reason I asked that question was people out there actually think that these people in the asylums don't want to work. I'm coming and trying to be honest at the moment and that's why I'm asking at the moment is what information, what statistics do we have? And I'm delighted to hear that they do want to work. And there should be as much emphasis put towards them as the work. Now, I do understand that locations are probably more. Like, for example, I come from Dundalk. The neighbours one we probably have would be Marginley and in Monaghan. And in fairness, the committee over the next few weeks intend to go and see the two centres. But that's what I'm asking. What entitlements do they get? Like, for example, if they want to work, and it's great to see that they do want to work, and the entitlements are there to work. Like, it's easy enough to say that, but when you start working, initially it could be in a week or 2 weeks before you get any kind of money, you're not there. But I'm trying to say, are they entitled to any like free public transport or like what are they actually entitled to do? Because like I'm delighted to see that the law has changed, right? That will work, and like there is very highly skilled people in there. And I think, as I said earlier on, I have people ringing me up in a daily basis. Look, I'm trying to get people to work for them, and they just can't get work. I had a painter around me this morning from my own Tennyson dog, has lost 11 contracts recently. At one stage he had 10 painters working with him, all he has is 2. And it's nearly impossible to get painters. That's what I mean. But one says, like, I'm just, like, even if I learn nothing today, I can go back and I can tell people, these asylum people, they came to this country for a reason, they came for a bit of help. And and us, we have to give them a bit of help. And to have qualifications, which you said to have, I think that they are entitled to work. Like, they don't want to be freeloaders. These people do want to work.
That's what we've established, yes.
The one thing I would mention is that when we did our report, we came across a phenomenon which was quite depressing. If these people were remained in direct provision centre for 5 and 6 and 7 years, they lost the will to work. And they became de-skilled. Their skills atrophied. And they became institutionalised. You know. Now, that should be, if you solve the long-term stages, you shouldn't have that problem anymore. But the people who come in first, and they're there a year, 6 months, a year, 2 years, they want to work. And I've heard one man said to me, I asked him in one of the centres one time, how are you getting on? I was inquiring about his legal papers. And he said to me, forget about my legal status. Just let me get up in the morning, have my breakfast, go to work, come back in the evening. I'll work for nothing. Come back in the evening, sit down with my wife and children and say, today I worked. So it means a lot to the new people coming in. And you're absolutely right. There's a missed opportunity somewhere there. Okay. I don't know how it can be worked out.
Well, that's what also too is we're able to look after 3,900 applicants at present, right? And there's roughly about 3,600 every year. What lessons have we learned over the last number of years? Like these 3,600 or these 3,900 applicants, are they new ones? Or are we starting from ones from day one, or what's happening? Because I would be honest, I wouldn't fancy being stuck in a confined space for such a long period of time, you know what I mean? And I just think to myself, what is the system doing at the moment? And have we learned that? It's like, is there many of these 6,000 there 5 years or 6 years and everything else at the moment? I don't think these people would want an amnesty. These people, as you say, would want the right to come out and to walk and do everything right. But have we learned anything? And is there more people employed to get these applications through? Like 3,900 seems a lot at the moment, so they've got something right. So what have we learned to get the process going at this stage?
Please, figures.
I think, going back over the years, sometimes people would say to you that if you make the system too good for asylum seekers, that it will attract more people to Ireland. I don't think anyone who's been to a direct provision centre would make that argument, but that is said out there. Really, the fact that the system goes on for so long actually has the potential to make it a target for people who come irregularly and who are not likely to get status. The faster someone's case can be resolved, the faster you can identify their legal entitlement to stay and to work, or discussions during the working group also concluded that a fast process makes it more likely that someone would voluntarily return home if at the end of that process they weren't given a status. So I would go back to that point, which is that the right to a quick decision is crucial in this. In relation to entitlements, it's very important to say, particularly in light of certain comments during the campaigning period of late, that asylum seekers are not considered habitually resident. Therefore, they don't qualify for social protection payments in the same way that an Irish citizen would. Somebody living in an accommodation centre is entitled to $29.80 per week for children and $38.80 per week for adults. That's increased considerably since the report came out, and it's implementing the recommendation of the McMahon report. So in terms of entitlements, people are reliant to a large extent on the food and services available in the centre, and they have this small living allowance otherwise to meet their needs. They would also be entitled to a medical card. And it's only when they get status or they are granted permission to work and they take up employment that they would have greater income.
Thank you.
Just my last question, and it's to do with human trafficking, and it's buying with a night this time. Listen, you mentioned there that it could take up to 2 years to find out and identify the lady or the woman involved there at the moment. To me, that seems a lot. I've seen a lot of documentaries lately dealing with trafficking, and I think it is frightening, especially myself, who is a father of 3 and having 2 girls in the house. Like, the last thing we want to do is for our children to be kidnapped or whatever it is at the moment and taken to a very, very strange country and everything else. Over the last number of years, do you find the level are rising? I noticed now over the last number of months the guards now have been putting, getting the enforcement going there. I see that there's a lot of people being arrested. Like, for the last number of years, there was nothing actually happening there. But I noticed now there's an enforcement there by the Gardaí. Can you give any kind of figures for the last 12 months or the last 18 months or the last 2 years? And can I tell you what success? What is your success rate is? Because I know that, like, if this woman who was taken from a different country, the first thing she want to do is probably get back home to her parents and everything else at the moment is. So can you just give us exactly what's actually happening there at the moment is? Are you working very close with the department? Are you getting much response from the Gardaí at the moment is? Because I'm not being smart. Like, it's to me. It's next thing to rape. Like, a woman like that at the moment, it's being forced to have sex, well as such, and these pimps, whatever you want to call them at the moment, and a lot of people seem to get away scotch-free at the moment is. So the more we highlight it, I think, and people just realise that this is happening in our own back garden here in Ireland, and I just want to basically just stop it.
Thank you, Deputy Fitzpatrick. Yes, Brian, please.
I think it's increased in terms of public awareness over the last number of years, and most people will be very surprised to hear that it does occur in every town and village in Ireland, unfortunately. And by the very nature of it, especially trafficking for the purpose of sexual exploitation, it is largely and by the most part organised by organised crime gangs, both Irish and international, and often in collaboration, who move women around on a very regular basis and make it very difficult for the women to escape the situations, first of all. But then when it comes to the stage of Garda investigations, they tend to be international ones that involve Interpol and Europol, and are very large and complex in that nature. We always, I suppose, as a law centre, we have to be conscious that those who come to us are often some of the worst cases that come to our attention. But as I said, we have seen cases of identification of victims of trafficking taking up to 2 years, and they're often the cases that we will go to the High Court with for judicial review to kind of review this whole process and why it's taking so long. I think one of the primary problems is looking at trafficking through the lens of immigration, it being an immigration phenomenon, but actually trafficking, of course, can occur with EU nationals who enjoy freedom of movement as well, who don't necessarily have an immigration issue but are caught up up in this system anyway. That's why I would say we have to move our perception of trafficking from being an immigration issue, although it often and mostly exclusively involves migrants, but to a gender-based violence approach, whereby we kind of say we need to be much quicker in our identification of victims of trafficking and much quicker in the supports we put in place around them. In terms of numbers of victims of trafficking over the last number of years, in 2016 the state engaged in 90 investigations of victims of trafficking. In 2017 there's 115 investigations, roughly split between labour exploitation and sexual exploitation, but more sexual exploitation than labour exploitation. And it looks like, well, the official statistics haven't come out, that 2018 there'll be an increase on that 115 investigations again. So it's something that is increasing in prevalence and increasing in detection, but what we're not seeing, I suppose, is an increased level of conviction of traffickers, which is the biggest single issue. And I don't think, we have very close contact with the Protective Services Bureau and the Gardaí, very close contact with the immigration authorities. I don't think it is because of a lack of willingness to do that. I think the whole problem of identification hampers their ability to do effective investigation. So they spend so long trying to work out the identification of a victim of trafficking that it takes from their overall powers of investigation. So that needs to be reformed entirely, and the guards need to focus on investigation so that they can convict traffickers. And I think they're very conscious of the international criticism they've received based on the fact that we haven't convicted a victim of trafficking, or sorry, convicted a trafficker in Ireland yet. And that's a hugely massive area. So while all this complex response at a state level is going on, often somebody is sitting in direct provision, going through the motions, essentially trying to get into a position of recovery and trying to get their life back on track. And these administrative arrangements that are built around it often hamper that person's ability to get back from a horrific situation into one of having kind of dignity and ability to be on their own 2 feet again. And I think what's true to say is that we have the component parts. We have the component parts of a good response to victims of trafficking. We have the will, but what we're lacking is a clarity of approach and resources put behind it. And I think things like the Sexual Offences Act that came out in 2017 that decriminalise women in these circumstances, but target buyers, are very important pieces. But they need to be implemented properly as well, and we're only seeing the initial stages of implementation on that particular piece of legislation. So it's a complex area, but I appreciate the opportunity to talk about it at length. Sorry.
To talk about it at length is a good invitation for me now to say what I have to say. For some reason, Deputy Fitzpatrick and Brian Kilran, in the course of your exchange, the recording equipment broke down. And Brian, I know it will be no trouble to you at all, but we want you to say it all once again when the recording equipment comes back. I'm only teasing.
Okay. What did I just say?
We're just suspending for a minute, just to see if we're able to get back on track.
Turn it off and turn it on again.
public session, I have to say. And may I indicate just to the panel and members that in order for the recording equipment to reactivate, we have to manually press the little button making a red light appear on our microphone. So I'm sure the technical aspect of it will be sorted in time. But what I'm going to do, I had some little questions myself, but I'm just going to conclude with one observation and just to share the situation with you. May I say just at the outset that I had formerly been a member of the Health Committee, going back in a previous Dáil. It's probably up to 10 years back, and we visited a number of centres, and at that time Dr. McMahon was very much of the order that you would have referenced yourself. Changes have happened, and that's to be welcomed. However, there still is a reality that for the greater number of people accommodated in these situations, particularly those who are longer waiting, these are suspended lives. That's the way I see them, suspended lives. And the 19 months referenced, it's totally unacceptable, albeit a significant improvement on the situation that applied. And I don't know if you're in a position, any of the panel, to advise if we have... That's all right, Frances. If you're in a position to advise, are there people currently in direct provision who are there for significantly longer than the 19-month situation? Do we know the stats on that, please?
We do. I have figures from the department which were sent to me as late as yesterday, so it could hardly be hotter off the press. I have difficulty in interpreting the tables, but persons residing in RIA for 4 years plus, we have a total, let us see now, 5 years plus, 75 with status granted, deportation orders made 41, and under consideration 230, a total of 346 of 4 years plus. We have people 5 years plus, 141, 6 years plus 66, 7 years plus 63, 8 years 16, 9 years 19, 10 years 26, 11 years 13, 12 years 8, 13 years 1, 14 years 3, a total of 702 people residing in RIA for 4 years plus. I can give you this.
Please, if you wouldn't mind, it would be very, very useful. It will certainly...
You have that number, those numbers. Now, could I just say one thing, Chair, if I might? In June 2015, when I finished the report with the working group, I was functus officio. I am no longer relevant. My job was finished. So I'm here today simply as a former chair of a working group that finished its job in 2015. Now, having said that, I still maintain an interest in the whole area, but I have no official status. So I just want to make that clear. I would classify myself, if I may do so, as just an informed advocate at this juncture, with no official status. However, I am being kept in the loop by the department for no other reason, just to keep me in the loop. So, in taking your evidence, you should pay attention to the people who are at the coalface in this matter. I've drawn attention to the differences that has occurred in the 15 years, but I'm not at the coalface. And there are many other witnesses, I'm sure, who will come before you, and I want you to bear that in mind.
Appreciate that, and thank you for sharing the fact that you have the statistics as up to date as you've shared. Thank you for that. So, just the only point that I'll conclude with then, and we've heard your own view, Dr. McMahon, in relation to this so-called emergency direct provision that has come into being in relatively recent times. We have challenged both the Minister and the Minister of State in relation to this matter, and indeed representatives of the agencies involved. And they point certainly that the Minister of State has made a former chair of this committee, that they don't have the accommodation available for the numbers presenting, and that their hand was forced. But I mean, we're talking not only in terms of private for-profit interests, because all of the other centres, bar the ones that were state-owned in the first place, which is 7 in number, they're all private for-profit entities as they are. However, this situation in relation to emergency direct provision, it comes down to what can only be described as block-booked hotel and other accommodation opportunities. And I'm familiar with some of these in my own constituency, and I have it to say that I've personally witnessed the situation where people are located in a very rural, on public transport served location, in significant numbers, with the big car park to walk around, which only conjures up a view in my mind of something akin to the exercise yard in a prison location. I find it utterly unacceptable. And what's more unacceptable is that the providers of this so-called accommodation and RIA seem happy to ignore the huge inconvenience that has occurred, where 100 and what number I can't just say here this morning, but it's of that scale, because one of these facilities, an hotel accommodation, had a previous booking for a wedding event. The entirety of that number had to be removed from where they were then staying for some time and relocated elsewhere in order for the hotel to honour the booking. Now, you know, that conjures up, these are human beings. To me, that conjures up, we'll move this, herd onto another field in order to facilitate whom? I think it is offensive, it's disgraceful, and I think it is a very black mark on Ireland in this time. So here we are, where we are, and we are going to go through our series of engagements with the widest number of people that we can physically accommodate. I have it to say that the expressed interest is beyond what we can actually facilitate, and that's why I'm laying great emphasis on the fact that we're open to receive submissions. We will be meeting next week with representatives of the Irish Refugee Council and Massey, and we will continue then. We've already decided earlier in our private engagement on the meeting for June 12th. We're there meeting on June 19th, and we have the planned visits, as Deputy Fitzpatrick has already referenced. There it is. I can only say to each and every one of you that we greatly appreciate your attendance here today, the submissions that you have forwarded to us, your opening statements, and on behalf of the Justice and Equality Committee, we did get a little more of them in attendance today than I was initially fearful of. It's great that we did. We're 11 in number, just to indicate to you, and I think we've had 7 of our number here, which is not too bad, given the week that's in it. So I thank you all individually. Mary Henderson, Brian Killoran, Brian McMahon, Enda O'Neill, Maria Hennessy and Caroline Stevens, thank you very much indeed for your participation and your assistance in this process. We will be in time inviting you to the launch of our report if you're in a position to attend, that would be great. But we do intend launching our report publicly with recommendations that will be the result of a process of discussion among our number, and hopefully we will reach consensus in relation to real and practical recommendations that will make a difference in the lives of people who are looking to us in times of agony in their lives for help and assistance. Thank you very much indeed. The Joint Committee is adjourned until 9 a.m. on next Wednesday, the 29th of May. Thank you, Senator Black, for staying the course.